Hello, welcome to Free Speech Unmuted. My co-host is Jane Bambauer of the University of Florida. I'm Eugene Volokh of the Hoover Institution at Stanford and emeritus at UCLA Law School. Today, we have a especially timely episode because it's about Monday's, or rather, to be specific, Monday, August 25th. We don't know when you're listening to this, but Monday's release of an executive order from President Trump. And the title of the order is Prosecuting Burning of the American Flag. And people might say, well, wait a minute, didn't the Supreme Court say that there's a First Amendment right to burn the American flag? Well, yes, it did. Yes, it did. Turns out the order tries to avoid that decision in some measure, although at the risk of ruining the suspense, so we think, or at least I think, I don't know what Jane thinks, I think that it probably doesn't really avoid the First Amendment problems. Let's quickly go through what the order does and doesn't do, and then we'll talk about what it can and can't do. Jane, actually, do you want to do that, or shall I? I'm fine.
Sure. Why don't you go over the order, and then we'll say I'll say a little something about how Trump made things a little bit confusing because
You bet.
of statements he's made
Yes,
about
absolutely.
the order. So go ahead. Why don't you summarize the order?
Makes sense. So the order begins with talking about our great American flags, the most sacred and cherished symbol of the United States of America, and of American freedom, identity, and strength. And then it goes on in much the same vein. But in the process, it also explains that desecrating the flag is uniquely offensive and provocative. It's a statement of contempt, hostility, and violence against our nation. The very fact that it says that actually becomes relevant to the First Amendment analysis somewhat later. It then acknowledges that the Supreme Court has had rulings on First Amendment protections, but says, notwithstanding that the court has never held that American flag desecration conducted in a manner that's likely to incite imminent lawless action or that is amounting to fighting words is constitutionally protected. That actually turns out to be technically true, although I don't think it does the work that the order expects. So far, this is just a statement of purpose. Then Section 2 is the measures to combat desecration of the American flag. That's what really explains what the order is aimed, or what the order is like to actually do and not just say. So it starts by saying the Attorney General shall prioritize the enforcement to the fullest extent possible of our nation's criminal and civil laws against acts of American flag desecration that violate applicable content-neutral laws while causing harm unrelated to expression consistent with the First Amendment. And it includes various things, including crimes against property and crimes against the peace. So on its face, this provision doesn't purport to outlaw flag burning. Rather, it says if flag burning is already illegal under some law, like, for example, stealing a flag and burning it is, of course, illegal. It's theft. And if it's a government, federally owned flag, it's a destruction of federally owned property. So it says when it's already illegal, the enforcement of those laws shall be prioritized when they involve flag desecration, which, by the way, can mean flag burning, but also some other actions with regard to the flag. Then it says that if the Justice Department or another federal agency determines that flag desecration may violate state or local law, it shall refer the matter to the appropriate state or local authority for potential action. Again, here, it's not actually purporting to outlaw something that is already that is currently legal. It's just saying refer it to state officials. And of course, executive order can't, generally speaking, outlaw that which is already legal. Then to the maximum extent permitted by the Constitution, the Attorney General shall vigorously prosecute those who violate our laws in ways that involve desecrating the flag and may pursue litigation to clarify the scope of the First Amendment exceptions. And then I'm sorry, actually, let me say a little bit about that. So that seems to suggest that maybe the government, the Justice Department will be trying to persuade the court cut back on protection, maybe even overrule protection for that. But again,
or seek a new exception. It sounds like it's
or seek some new exception.
There's a new unprotected form of speech.
Right. Though again, note the order doesn't say
Correct.
It's
To do
illegal
that.
to burn a flag.
Right.
Can't say that, but it's sort of urging the government to kind of push to narrow whatever protection might be present, which of course the Justice Department is entitled to do as a matter of its litigation strategy, of course, consistent with legal ethics. It can't just deny the existence of existing precedent, let's say, and the like. And then the fourth section, which is probably the one that will have the most direct effect, is that Secretary of State, Attorney General, and Secretary of Homeland Security shall deny, prohibit, terminate, or revoke visas and various other immigration benefits whenever there's been, or seek removal from the US, so seek deportation pursuant to federal law, whenever there's been an appropriate determination that foreign nationals, so non-citizens, people who are not US citizens, have engaged in an American flag desecration activity under circumstances that permit the exercise of such remedies pursuant to federal law. So what it's saying is kind of, just as we've been going after people who've been saying various things, or aliens, non-citizens who've been saying various things, to the extent we think federal law allows us to say deport them for that. The same should be done when they burn the American flag, so long as that is consistent with federal law. Just to foreshadow a little bit of the constitutional discussion, it turns out that here, the First Amendment law is unsettled. First Amendment law is quite well settled that flag desecration cannot just be outlawed simply because it's flag desecration. It's well settled as to other matters we'll get to later, but it's unsettled, as we talked about in a previous episode, with regard to speech by aliens or symbolic expression by aliens, like flag desecration. So this is something, again, I can't say this provision is clearly unconstitutional. Maybe it should be seen that way. Maybe the Supreme Court maybe eventually will say that it's impermissible to deport aliens, let's say, for symbolic expression that's constitutionally protected for American citizens. But I think we have to candidly say that that is an uncertain.
And on that issue, if listeners want to understand why that is unsettled, they could listen to the episode that we did about Mahmoud Khalil, the Columbia student whose visa, well, actually, no, he actually wound up getting his, it's even a harder case because he wound up getting his citizenship and they're trying to reverse it. But in any case,
did he get?
Oh no, you're right. It's a green card. He got his permanent citizen. He did have a permanent residence.
Right. And so we're going to include the exact title of that episode and perhaps a link to it, if that's possible, in the show notes.
Good. Yeah. Okay. So adding some complications. So Eugene just described what the executive order does, which is what we're going to focus on from now on. But, or, after my little spiel, but adding to the confusion is that upon signing this executive order, President Trump kind of exaggerated what it was that the executive order attempts to do. Or I don't know. I don't even think it's fair to call it an exaggeration, because what he said is, if you burn a flag, you get 1 year in jail. And he said, you will see flag burning stop immediately. And so, so he was implying that he was signing something that just provided a general ban and, criminal liability based on burning a flag, period. Or at least, he wasn't adding much nuance to it. And his anticipation that flag burning should stop immediately, that too suggests that he's expecting some sort of crackdown, like this order would enable prosecution of flag burning almost wherever it occurs. So,
right. Although some people claim, and I don't know, but it's not implausible, is that what he's really expecting is that his enemies, generally on the left, will start burning more flags.
Oh, I think that's not only plausible, but very good politics.
Exactly. And whether or not he can prosecute them, he's going to have a political victory.
Yes, all the better if he can't prosecute them.
Exactly. So that is perfectly possible. And again, as you point out, would even be good politics, whether it's good statesmanship or not.
No, I do not mean that. I mean good very effective politics. So, okay, so one example. So let's maybe starting the discussion of the background case law. We already talked about Johnson, the flag burning case. But another example, in addition to just sort of general prohibitions on, for example, starting a fire in a public place and then using that to bootstrap this flag burning, the order also says, well, if you're burning a flag in a way that constitutes incitement, well, then prosecutors should go ahead, focus on those cases and make sure to prosecute them. And so the first thing I wanted to ask you, Eugene, I'm pretty sure I know the answer, but if there's a form of expression that's already unprotected, and Trump is simply directing the government to take that form of already unprotected speech and prosecute it, possibly to the exclusion of other types of incitement. Does that get a free pass from the First Amendment?
No, it does not. So this is the problem with the rationale behind the order. The rationale behind the order, recall, is some kinds of flag burning are already unprotected. For example, if you steal a flag, that can't be protected. Or if it's fighting words involves personal face-to-face insults, not just offensive political statements, but personal insults. Hard to imagine just how that would happen. But I could imagine somebody burning a flag and saying to someone, let's say, you're essentially, let's say, insulting the person, and in the process, burning the flag and maybe tying it to the personal insult.
Oh, right. So
or
doing it in front of a service person, a service member.
Maybe, but then it would also have to be. It's not just that I'm doing it in front of a service member. It has to be tied with personal face-to-face insults, something else. Let's go after it, especially because it's flag burning. And that kind of selective enforcement based on the content of the message and based, in fact, on the viewpoint of the message, because, again, the executive order starts talking about how this is so offensive and so bad. That is itself unconstitutional. So a law, let's start with a content-neutral law. A ban on defacing federal property. Imagine somebody takes a federally owned flag and burns it. Okay, that law is constitutional when applied to burning an American flag because it's content neutral. But when the government is essentially saying we are prioritizing going after it because of the message, that makes the law essentially content-based and viewpoint-based in enforcement, and thus makes that enforcement unconstitutional. It's not just my speculation. Consider Supreme Court's opinion in McCullen v. Coakley, a 2014 case involving restrictions on speech outside abortion clinics. The court actually struck down those restrictions, but it said they are content neutral because they apply equally to everybody, pro-abortion or anti-abortion. But if the police do not enforce the law equally against clinic escorts and instead selectively target anti-abortion protesters, quote, such allegations might state a claim of official viewpoint discrimination, close quote. So the court was saying, look, or the majority of the court was saying, look, this law is content neutral, but on its face, but that we'll only treat it as content neutral because we're not seeing any evidence of viewpoint discrimination and enforcement. Then the court favorably cited, then right around there, the court favorably cited a Ninth Circuit case, Hoy v. City of Oakland from 2011, which involved similarly a content-neutral ordinance, but there was evidence it was selectively enforced against anti-abortion protesters. There was a city policy, essentially, that took this facially content-neutral ordinance and selectively enforced it against anti-abortion protesters. And Hoy, again, the case that the court favorably cited, says Oakland's enforcement policy is a constitutionally invalid content-based regulation of speech. By adopting that policy, Oakland has taken sides in a public debate in a manner that the Constitution does not permit. Exactly the same would apply here. That a ban on defacing federal property is facially content neutral. But if there's a policy for prioritizing enforcement against flag burning, then in that case, that policy is a constitutionally invalid content-based regulation of speech. Or consider the opinion from 2023 by Judge Naomi Rao. Very smart, I think, well-respected judge. I respect her very much. A Trump appointee from his first term, and DC Circuit judge. So she wrote this opinion for a three-judge panel in a case called Frederick Douglass Foundation versus DC. And the case concerns, I'm quoting here, a constitutional challenge to selective enforcement of the District of Columbia's defacement ordinance against some viewpoints, but not others. Apparently, at least the allegations were, that DC allowed people to write Black Lives Matter on various streets, sidewalks, storefronts, and such, but did not allow the plaintiffs to have a Black preborn lives matter message, to have them write in the same similar places this Black preborn lives matter message, so an anti-abortion message. And the DC Circuit says, in this opinion by Judge Rao, look, the defacement ordinance may be perfectly neutral on its own, but the foundation here is plausibly alleged the district discriminated on the basis of viewpoint in selective enforcement of its defacement ordinance. Exactly the same language. I mean, if I were the lawyer for a flag burner who was prosecuted under this policy, I would just quote that language from Hoy, quote that language from McCullen, quote the language from Judge Rao's opinion, and say, look, just as selectively targeting anti-abortion messages for special enforcement, selective enforcement, even under a facially content-neutral ordinance is unconstitutional. Likewise, selectively targeting anti-American messages is unconstitutional.
Let me ask you a couple clarifying questions. The case of Hoy that the Supreme Court cited to, and by the way, let me first ask, the Supreme Court's citation to Hoy is the closest we get. Like, we don't have a case where the facts before the court are clearly on point here. They've cited a case where there was such a policy of selective enforcement, and they decided it approvingly. Okay, right. So, but Hoy seems different still from the Frederick Douglass Foundation case in the following way, that at least in Hoy, there was some, my understanding at least is that there was some evidence, like a written policy, like some, or even if it's an unofficial policy, it was still written, and therefore, you know, there was evidence in the record that this was what the police planned to do. Whereas in Frederick Douglass Foundation, my impression from what you just said is that there was no such express evidence, but rather there was a pattern of non-enforcement except for this message. So that's very interesting, because it's allowing evidence of a history or pattern of selective enforcement to do the work of showing viewpoint-based enforcement, even though if you think about like the police force, it's an amorphous blob of lots of different people making lots of different decisions. I could imagine the court, I'm glad they didn't, but I could imagine a court going the other way and saying, look, you can't prove that this police officer would have let the other messages go if he happened to see that, you know.
Right. There is the law, and then there's what you can prove.
Right.
Yeah. So you're absolutely right that there is this difference that has a practical effect. As a general matter, selective enforcement claims are permissible, or that is to say, can be brought in order to try to defend against a prosecution. They can be brought whether or not there is a written policy of selective enforcement. It's just that if there isn't such a policy, it's not easy to prove, especially since lots of people sort of say, "Oh, I was pulled over for speeding because they didn't like my license plate." No, maybe you just were speeding. Well, what about other cars that weren't speeding? Well, they can't pull over everyone, right? So a lot of people make selective enforcement claims. Usually it goes nowhere. Because there's not enough evidence, and courts usually require a lot of evidence. But in Hoy, there was in fact evidence of an official policy that was present. And guess where else there is evidence of an official policy? In President Trump's executive order. It's right there in Section 1. It's saying, essentially, it's not just like President Trump calls up his AG, says, spread the word to your US attorneys, that they spread the word to their people. I want something done about flag burning wherever that's possible. Even that, presumably somebody would blow the whistle and there'd be some evidence, but at least, might say, well, I don't know, is there really proof of that? What if it was done in a really subtle way? Maybe there wouldn't be enough proof. But here, he's putting the proof down in writing. That the federal prosecutors shall prioritize one particular kind of defacement of property that sends a particular kind of highly offensive message, the executive order says. So this is, again, if I were the lawyer for somebody being prosecuted for flag burning after this policy is instituted, I would say, well, we know why this was done, because this is what the executive order says. It says so right there.
Okay, one more question, if you don't mind.
Never mind.
So the flag burning cases, Johnson and Eichmann, they sort of stood on the shoulders of the O'Brien case that was decided in the 60s. And O'Brien, listeners are probably familiar with it, even if you don't know the name of it. It's the draft card burning case. And that was the case where the Supreme Court, most clearly recognized that that conduct can be expressive and protected on the basis of its expression. It's often described as an expressive conduct case that makes clear that kind of creates. I think the best way to understand O'Brien is that it says that even a content neutral law, if enforced for a content, if enforced against someone who's using the conduct to express a message, could violate the First Amendment, even though the law that's being used against them is a regulation of conduct. But O'Brien, the reason I want to bring this up is that O'Brien never sat well with me, because it seemed to me that O'Brien was an example of selective enforcement, that the court did its best to explain that, no, the government really does care. They don't want people destroying their draft cards and their certifications, their proof of registry with, but if you look at the congressional record, it seemed that they were worried basically about two things. One was people using these cards to claim to be other people. So basically, false impersonation. Or the other thing that comes up is defiant destruction of the draft cards. So I'm wondering if O'Brien, do you feel the same way about O'Brien, or is it's probably better for my mental health if I just assume what the court insists was true, which was that, no, this was not enforced based on the message. It was just kind of it was an act of enforcement that the police would have done anyway.
Right. So O'Brien, which is a Vietnam War era case, involved a federal statute, which generally speaking prohibited destruction of draft cards. By the way, what didn't it do? It didn't prohibit destruction of copies of draft cards. If you want to burn a copy of a draft card, you're free to do that. The theory behind the law, at least as the court accepted it, was a draft card is a government document. It's not necessarily a matter of property as such, but it is a government document that the government issues. It plays an important role in the Selective Service Registration System. You can't destroy this government document. Again, you can destroy copies if you want. You can't, but you can't destroy it in public or in private. It doesn't matter what. Even if you destroy it for non-symbolic purposes, you just don't want to have it on you or whatever else, you can't do that. There was some evidence in the legislative history that some of the legislators who voted for it voted for that law because they were outraged by the message of defiance and
Yeah.
lawlessness they saw essentially as sent by the burning, especially the public burning of draft cards. But that was just a few of the legislators. And the court said, look, this law is on its face uh, content neutral. In fact, it's speech neutral. It applies to symbolic or non-symbolic expression. The fact that a few legislators may have backed it for ideological, because they did disapprove of the ideological message, that can't be enough to invalidate it. There were, after all, hundreds of legislators who voted for it. And as you point out, in principle, there might be sometimes some exceptions, even from content neutral restrictions on symbolic expression when they're applied to things that have expressive value. But we give a lot of deference to the government when it enforces content neutral laws, and this is one such law. So you may agree or disagree. Maybe the court should have said, well, we know what's really going on with this law. It's really aimed at suppressing a message, and
or even as applied in this case.
Right, or as applied. I have no particular reason to think that there was a policy of prioritizing a prosecution of people, let's say, who publicly burnt the draft card. It may just be that much of the time the prosecutors have no idea that someone's destroyed his draft card. But if he destroys it in public and makes a big public thing of it, well, that's when they know. So in any event, so you may agree or disagree with O'Brien, but the court in Texas v. Johnson said, look, this law, the ban on flag desecration, is based on content. The harm is not that there's some government document that's being destroyed, or a government government-owned flag that's being destroyed. It applies even to privately owned flags, right? People can create privately owned flags. They can because it's just privately owned, they have a First Amendment right to symbolically destroy them as well. And any attempt to restrict that has to be simply a mechanism for going after the message. I think it's probably right. By the way, some people say, well, wait a minute. Why are we even talking about this under the Free Speech Clause? Because burning a flag isn't speech. And I just thought it was worth mentioning this, in part because I wrote an article about this very issue quite a while ago now, and law professors always love to talk about their articles. But I do think it's relevant. I actually looked at the history of how American law, and before that English law, dealt with symbolic expression, both for purposes of protecting it, but also for purposes of restricting it under things like libel law. And it's quite clear from before the revolution to right around the revolution to after the revolution, symbolic expression was treated as basically functionally identical to verbal expression and pictorial expression. So, for example, it could be a libel to burn a person in effigy when you're basically conveying a defamatory, reputation-damaging message about the person. Painting a man with a...
Seems like pure opinion to me, but go ahead.
Pardon?
Seems like a pure opinion rather than a statement of fact.
Today it would be treated probably as opinion, but back then, certain kinds of opinion would be actionable.
Yes, true.
Or painting a man with a fool's cap or coat, or with horns or ass's ears, donkey's ears. So that's pictorial expression. Likewise, for more symbolic expression, placing a wooden gun at an officer's door, thereby implying cowardice. That too was treated as basically tantamount to verbal expression. And likewise, when it came to discussions of constitutional law, it was quite routine for them to be treated the same. For example, the very first American court opinion that held a speech restriction unconstitutional on free speech or free press grounds actually discussed a painting as tantamount to a printed book for free speech purposes. And going forward from the framing era, the very first Supreme Court opinion that struck down a government action on freedom of expression grounds, basically First Amendment, but as applied to the states through the 14th Amendment, was Stromberg v. California in 1931. It was a symbolic expression case. It involved a law that banned the use of, I think, essentially red flags as a symbol of opposition to organized government. The very first law case that struck down something as a speech compulsion under the First Amendment was West Virginia Board of Education versus Barnett in 1943, also involved, together with verbal expression, symbolic expression. There, the flag salute. So Texas v. Johnson rests on very, very firm footing in American history and American precedent as protecting a symbolic expression when it's targeted because of what it communicates. Right. The same way as it protects verbal expression.
Very good.
So there's something else I want to mention, because you asked, or you talked about this earlier, Jane, and want to make sure we bring this in. So far, I've been talking about content neutral restrictions. Like the classic example is a ban on destroying federal property, or, as you pointed out, a ban on burning things. There's actually a case from Ohio Court of Appeal from 2003, where somebody was prosecuted for burning a flag. He just was prosecuted under a generally applicable fire prevention ordinance and didn't have any evidence there was some selective policy of targeting things. I think a lot of law enforcement people in areas I not only come from California, don't come from California. I've lived 50 years in California. Not only that, but until a few years ago, we lived in the Pacific Palisades, the very Pacific Palisades which is now burned down, thankfully for us, after we sold our house there. So, when there's law enforcement in an area of fire hazard, they take a dim view of people burning objects, whether they're flags or not. So those are content neutral restrictions. But what about bans on incitement of violence, or bans on fighting words? Again, these personal insults that can lead to violence. They're not technically content neutral, but they are permissible. That is to say, those bans are permissible. But again, selectively enforcing those bans as a policy against particular messages is also unconstitutional. And the Supreme Court made that clear in a case called RAV v. City of St. Paul in 1992. The city of St. Paul had not a general ordinance banning fighting words, again, personal face-to-face insults that are likely to cause a fight.
They did not have a general ordinance?
Their ordinance wasn't that. The ordinance they were applying wasn't a general.
Was not that.
Yeah, instead, it was a selective ban that targeted fighting words that angered people based on race, religion, and the like. So essentially, let's say bigoted or prejudiced fighting words. And the Supreme Court, by a 5-4 vote, but said, look, it's unconstitutional to selectively target subsets of fighting words, exception based on viewpoint, or even based, in most situations, on content. Again, that would apply fully to this very executive order, that if the prosecutors are prosecuting fighting words or incitement because it violates the general law against fighting words and incitement, and that's all the evidence that there is, well, they're entitled to do that, because there are First Amendment exceptions, narrow ones, for fighting words and incitement. But if it's clear that they have a policy of prioritizing fighting words or incitement that convey this offensive anti-American message, that very policy makes that prosecution potentially unconstitutional selective enforcement. So I do think there was an attempt to try to write this executive order in a narrow way, in a way that wasn't clearly contradictory to Texas v. Johnson. I appreciate that, but I don't think it ultimately succeeded, because in the process of prohibiting or prioritizing fighting words, the very fact that it's prioritizing, the very fact that it's prioritizing desecration of the flag in the various laws that it's asking prosecutors to enforce, that makes it itself a First Amendment violation.
That makes sense to me.
Well, makes sense to both of us. Let's see whether it makes sense to judges. I will say, on some things, I gotta say, I don't know. For example, as I mentioned earlier, when it comes to the question of whether aliens should be deportable based on their speech, even if the speech would be constitutionally protected for citizens, the law is unsettled, and I'm not sure which way the justices will go. But here, I think the law is unusually clear, and it seems to me unusually clear that the justices will indeed recognize that this executive order calls for unconstitutional selective prosecution. Also, to the extent that I think some people are saying, well, what if the justices change their minds about Texas v. Johnson and just say that flag burning could be banned altogether? I don't see that
I'd
happen.
be surprised. Yeah, I don't see it happening either.
The court today is more conservative than it was back then, but of course, Texas v. Johnson was written by conservative Justice Scalia, joined by moderate conservative Justice Kennedy, and today's conservative justices, not in all situations, but in many situations, have shown themselves very protective of free speech rights, especially when it comes to content and viewpoint-based restrictions. And what's more, Texas v. Johnson has been repeatedly cited by conservative justices as evidence that, yes, First Amendment is very strong. We don't allow restrictions on various kinds of speech that may be offensive to people. We don't allow bans on so-called hate speech. One piece of evidence is, look, the First Amendment protects even flag burning. So I think the conservative justices, and I'm quite sure the liberal justices too, are I think quite committed to maintaining that precedent that they have cited on many occasions in the past.
Well, and I think there's another reason as well, which is that to make an exception for flag burning would kind of be a reversal of Stevens, U.S. versus Stevens, where the court insisted that they're not going to be in the habit of doing freewheeling discovery of new exceptions. And so if they open that can, who knows what the court in 20 years with a different, with a different makeup, sort of ideological makeup, might do with that invitation. And so I do think that conservatism itself kind of tends to favor the upholding of Johnson.
Right. So, of course, Donald J. Trump may be many things. One thing we know he is a politician. One thing we know he isn't is a lawyer. And as we mentioned at the very outset, it may be that this executive order is perfectly fine politics, maybe excellent politics. I don't know. I'm not a politician. I'm a lawyer. So I got to focus on things that I know. But it may be that it's very good politics. All we're saying, I think, together on this is it's not good law, in the sense that if there is an attempt to actually enforce it, bracketing this question about enforcement with regard to non-citizens, which is a complicated question that presumably the court will consider in other contexts soon enough. But if there's an attempt to enforce it, it's not going to go.
All right.
All right. Unusually clear, I think, for our podcast, where sometimes we say we don't know, nobody knows, or maybe this, maybe that. Here, I feel pretty confident. It sounds, Jane, like you do too.
Yep, I think so.
Well, all right, folks. Jane, great pleasure recording this with you as always. And we will be having more episodes coming down the pike shortly.
Yep. See you next time.
See you next time.
This podcast is a production of the Hoover Institution, where we generate and promote ideas advancing freedom. For more information about our work, to hear more of our podcasts, or view our video content, please visit hoover.org.